Yes, Mr. Bassett.
Was making the point that without applying for judicial review, the respondent would never have known of certain facts which it only came to know at the merit stage of its review application. Those facts, amongst others, relate to a decision purportedly taken by government on the 6th of February that it should disclose its sources of fund. Now, the appellants seem to rely on the decision of MTEL, where the Supreme Court in Mauritius in 2002 set aside an application for review because the application revealed that issues raised were inextricably connected with the averments MTEL had made in its civil claim. And the court said we cannot prejudge those issues and prefer to leave them for determination by the trial judge. Now, it is the respectful submission of the respondent that the situation in its JR application is different from the situation in MTEL. In MTEL, the civil claim was entered before the appeal against the refusal by Mauritius grant. In our case, the respondent entered its civil claim after the judgment of the court at merit stage. The reason for this is very simple. It is because the respondent only became aware of a number of facts in the course of the JR proceedings. At the time the respondent lodged its review application, as far as it was concerned, I think I made the point this morning, if it was successful in its initial prayers, the project would have continued. But before the judgment at merit stage was given, yet after pleadings were exchanged, the EIA license had lapsed and a request for extension made to the Ministry of Environment was refused. We have pleaded this at paragraph 83 of the plaint with summons, and this is why the respondent changed its initial prayers. We have dealt with this point at paragraph 98 of our written case, and there is no point for me to repeat it here. Paragraph 98 is at MS page 1094. Further, Lords, Lady, the decision of the court in MTEL in 2002 has to be seen in the light of the observations made by the board in the case of Pandey, to which Mr. Guthrie referred this morning. And subsequently, your Lordship, Lady, will note that when the matter was remitted back to Mauritius, the court did not follow the decision of MTEL, but applied Privy Council judgment and treated the motion and affidavit of the claimant as a plaint with summons. But one important point to note, Lord, we are referring to Pandey at tab 25, MS 1590, and the message I want to take your lordships and my ladies at page MS 1593, top of the page, 2 sentences before last. A claim for damages could be included in a claim for J in the UK, as it appears from Rule 50 of the former Civil Procedure Rules 1998. The principles applicable under that rule cannot be of much assistance in the present situation. As it has already been seen, the JR proceedings initiated by the applicant never included any claim for salary or damages. These only arose for the first time in the Court of Appeal before the Judicial Committee. On the other hand, it is absolutely clear that the case cannot proceed by way of motion and affidavit, as such a procedure would not provide all adequate safeguards for a fair hearing. Affidavits raise a number of factual issues which are in dispute, which cannot be resolved solely on the basis of affidavit evidence. Party to such proceedings should be entitled and should be afforded the opportunity to test the evidence, cross-examine any witness, and should be able to carry out the examination of witnesses to testify, etc. So, in the last paragraph, the court takes the view the best alternative would be to resort to the Supreme Court rules of Mauritius, ordinarily applicable to civil claims, and the motion and the affidavit would contain the elements and facts of a complaint, which the respondent would have a right to traverse. And the court says that the advantage of following this rule would be to afford the parties the chance, the opportunity of applying for particulars, disclosure, and so forth. And this is why the court directs at 1594, the contents of the motion and affidavit would be for purposes treated as a plaintiff summons, and the case would be mentioned for exchange of pleadings in accordance with the rules. So it is pretty much clear, Lord, that in Mauritius we have that added hurdle, which makes it pretty much difficult to tag along a claim damages with a JR application. But in any event, insofar as the present matter is concerned, we would not even have been able to do so because we would not have been able to plead the necessary facts which would engage the responsibility of the state as principal for the act of its agents in their public duties. Unlike the MTEL case, in JR application, the court made a number of findings of fact. For example, I will only give examples at MS 832, paragraph 12 and 14, MS 833.
I'm sorry, Mr. Bassett. It's no doubt because I'm easily the eldest of this panel, but I'm having some difficulty in hearing you. I wonder, would it be possible to move the microphone a little closer to you, please?
Closer. Yes, my lord, I will.
It's much better.
Is that better, my lord?
Yes.
Yes, it is.
Right. So I was saying, Lord, that in our present case, the court has made a number of findings of fact, and I was giving examples. MS 832 at paragraph 12, MS 832 paragraph 14 as well, where the court records that from various statements made by the minister to the press and the questions put, the fate of the project, of this power plant project, was of great general and public interest and of importance for Mauritius. We also have MS 835 at paragraph 25, where the court states, we may observe that there is no dispute that for all intents and purposes, and at least from the perspective of government, the project has come to a halt. City Power has not been informed directly, but indirectly by way of statements at the National Assembly on the 1st and 2nd April. We also have another finding of fact at page 841, paragraph 46, paragraph 46, 47 as well, where the court finds it appears that no written communication of any decision, if there was, to the new condition imposed by the Ministry of Energy and agreed upon by City. Finally, page 844, paragraphs 55, 56, and 57. Now, in respondent's respectful submission, those findings of fact will not be revisited in a civil claim. Now, the board would have seen, of course, the complaint was summoned, and the board would be aware of how one engages the responsibility of the state in Mauritius under Article 1384, which is a kind of vicarious liability, where in order to be rendered state liable, you must necessarily vote.
Sorry, again having difficulty. Do try to keep your microphone as close to you as possible. I know it's difficult.
Yes. So I was saying that in Mauritius, under Article 1384, one can only engage the liability state if one proves agents of the state of their public duties have committed a fraud or act of treason, and property for this required is to be a supplemental bundle and violation has that piece of thing is the state which is at stakes.
I'm sorry. I'm
afraid we're going to have to pause for a moment, Mr. Bassett. We are having great difficulty making out what you're saying. Even though you have the microphone, I can see right beside your mouth. I think I suspect it may be a matter of trial and error. Shall we? I think we might adjourn for a few minutes so that we can. So that you can. We'll get our technical staff to come and see if they can work with you to find a way in which it works better without you having to do it in the formality of this hearing. So if you can remain where you are, we will adjourn and we will have our technical staff come and talk you through this to see if we can find a way forward.
Could I just make a practical suggestion, which is what may be happening, but it'll be checked, is when you're too far away from the microphone, it's not picking it up sufficiently distinctly. When you hold it very, very close to your mouth, I'm getting a sort of feedback relay which makes it difficult to understand. There may be a sort of sweet point between those extremes where it works better. I'm so sorry, that's just a practical suggestion that you can explore with our technical people.
Yes, it's a matter of trial and error.
Yes, it may well be, Mr. Bassett. But we'll adjourn in the meantime, and we'll see if by trial and error a way forward can be found.
Thank you.
Well, Mr. Bassett, I'm sorry we've had these interruptions, but I should assure you that it hasn't diminished the impact of your submissions. We are listening attentively to all you have to say.
Thank you, Malu. I hope we have reached your technical people at the Privy Council and ourselves. I hope we have reached the right measure for your lordships to hear me clearly.
We're hearing you very clearly at the moment.
Right. So I was, my Lord, referring to the authority of Ashu Chongqing against the State of Mauritius. And I said that this is to be found in the supplemental bundle of authorities at tab 6. And the relevant passages are from page 4 of the judgment, where the court explains how tortious liability of the state is engaged. I will not read it, my Lord, because of time constraints.
Yes.
But let me say that the judgment also quotes a French work of doctrine, which is René Chaput, Droit Administratif.
Yes.
Your Lordship and my Lady will find it at tab 8.
Yes.
And I will also say that the case was upheld on appeal recently, and the judgment of the Court of Appeal is at tab 7. And in fact, the judgment of the Court of Appeal refers to a recent judgment of the board in the case of Trans-Pacific Export and the State of Mauritius. And this is at page 6 of the judgment.
Yes.
The point I wish to make, Lord, is simply that the particular circumstances of this case made it well nigh impossible for City Power at the JR application stage to bring in any claim for damages against the state, for the very simple reason that it was totally in the dark, apart from reading statements made in Parliament, which were picked by the media. And therefore, the respondent City Power could not meaningfully, at that point in time, long claim in damages. But of course, the fact that it has lodged a private claim in damages in our respectful submission doesn't mean that it could not have pursued a claim for judicial review, provided, of course, that the requirements for judicial review are met. And in my humble submission, I would say that the requirements for JR are met for several reasons. Um, the board would be aware that the respondent came up with this power plant project on a build, own, and operate basis as an independent power producer in April 2006. Now, there are several independent power producers operating in Mauritius. They provide about 55% of electricity supply of the CEB, and all of them are traditional local sugar sector companies that use coal and that use, during the crop season, that use the bagasse from sugarcane. Now, when the respondent approached the Board of Investment, and your lordships and my lady will find the legislation regulating the Board of Investment at tab 1 of the supplemental bundle, the Investment Promotion Act, which explains the objects of the board, its functions to encourage and participate and rationalize investments, and as well as the fact that it is empowered to issue investment certificates in respect of various projects which are approved. So a letter of investment was issued to the respondent by the BOI. The board will find this at MS 277 278. 277 278. In the opening paragraph, City Power is told that further to a policy decision of the Ministry of Public Utilities, which was conveyed to the Board of Investment on the 21st of April, the project proposal of City Power can be accommodated in the CEB power sector capacity expansion plan. So City Power is informed, we are pleased to inform you, your application has been favorably considered. Now, on the 30th of October, MS, page 2.
Well, Mr. Bassett, if you're moving away from that letter, could I just mention two things about it? One is it's actually for a differently described project, I think. It's 3 times 50 megawatts.
3 times 55
And also
megawatts.
It's subject to an expiry on the
It is.
22nd of October 2006. Now, it's fair to say that was extended, I think, to March 2007. But I don't think we've seen any extension beyond that. So,
no, we did not receive any extension beyond that.
So this, I mean,
there is no document to that effect.
It's useful as part of the historical background to the case, if you like, but this letter, by the time we get to 2014, 2015, has really receded into the background by quite a lot, hasn't it?
This is correct, my Lord, this is correct. But the point I'm trying to make is that in 2006, it was pursuant to policy decision of government that this power plant project was approved. And indeed, this is rate rated at MS 282 by the CEB, the partner of City Power. Informing the latter, we have been directed by the Ministry of Public Utilities to inform you that approval has been obtained for the Mauritius City Power to install and operate a coal-fired power plant with a 2 times 55 megawatt generating units. Given the change in project size, we would appreciate receiving your revised proposals containing detailed technical and financial information as soon as possible. So my point, my lady and lords, is very simply that it is the Ministry of Energy, it is the government itself, which brought to the CB, as a result of government policy, the coal power plant project. Now, this should certainly, in my respectful submission, dispel any doubts as to the circumstances surrounding the project, which apparently was invoked subsequently in the decision to abandon the project. Because when we look at the cabinet decision, which is reproduced at MS 834.
So sorry to interrupt again, Mr. Bassett. On page 282 that you took us to, it seems to be a different ministry, the Ministry of Public Utilities, from the two ministries with which these proceedings are concerned.
Yes,
is that right?
It is the same. It is the same ministry.
Which one?
It's the Ministry of Energy and Public Utilities. It changed its appellation.
So we should read, is this right? We should read Ministry of Public Utilities as Ministry of Energy in our case?
Yes. In fact, it's called Ministry of Energy and Public Utilities.
Yes, thank you.
So I was saying, Lord, that the fact that this was brought by government itself to the CEB should dispel any doubts as to the circumstances surrounding the project. Because when we read the cabinet decision, which is reproduced at MS 834 in the judgment of paragraph 21, we find that one of the reasons why government chooses to abort the project is given to be the circumstances surrounding the project. The circumstances surrounding the project. Although, when we read further statements of the Minister of Energy to the National Assembly, April, what we find is that the only reason why the project was aborted is that City Power was unable to provide proof of its financial capabilities. Board will see that in the SFI at MS page 1034, items 33 and 34. 33 and 34. Now, be aware that in 2008, a number of agreements were signed between City Power and CB as its partner. This is mentioned in the SFI at MS 1026. Item 7. The board would also be aware that the first draft of the implementation agreement was discussed between the Ministry of Energy and City Power as early as 2009. We can see at page MS 403, MS 403, that when 2009 draft implementation agreement was circulated, the Ministry of Energy reacted to the draft dated. If we look at page 403, starting from the bottom, we find that City Power sends the IA for review, and then Mr. Dasai, of a government official, says, "Dear Mr. Sundram, with reference to your email, please find attached the final version of the implementation agreement." And then we have on top of the page the revised implementation agreement you sent to us on the 19th is in order and acceptable to us. I have attached clean copy for execution purposes. Now, the board will note that at that point in time, the Ministry of Energy appeared ready to sign the implementation agreement, presumably before even having carried out any form of due diligence on the financial capabilities of the respondent. And the reason for this, in my respectful submission, is pretty obvious. The implementation agreement does nothing more than guarantees the payment obligations of the CB once the project has been completed and starts producing electricity, which the CB has undertaken to buy from City Power. And the board will be aware that CB is the only statutory undertaking in Mauritius that is responsible to provide new generating stations, that is responsible to improve the generation, transmission, distribution, sale of electricity. This is to be found in the Central Electricity Board Act, which my lady and your lordships will find in the bundle of authorities at tab 2. Tab 2, MS 1118. And the relevant sections I want to refer to the board are 3 at MS 1119, section 10, MS 1122, section 12, MS 1123, and also 13 subsection 1, where investment of the board are stated. Now, section 21 at MS 1128 is also important because it states what are the powers of the minister in relation to what kind of directions the minister can give to board. Now, surely in 2008, and later we will see in 2013, after the City Power had obtained its EIA license, City Power and the CB signed a number of agreements, Children's Agreement, Coal Supply Agreement, a Power Purchase Agreement, and so on. And the respondent submits that the financial capability as set out in condition 15 of its license is a completely irrelevant consideration in the execution of the implementation agreement. Otherwise, it would have been an issue in 2009, but it was not made an issue. And when the 2015 was circulated, the only comment that the Ministry of Energy, that government does not guarantee the obligations of any private company. That was, of course, because the first bank letter that had been circulated along first bank is dated 16th of October 2014, and it's next to a covering from City on the 13th of September 2014, the bank had only assumed that the implementation agreement would have guaranteed the obligations of the borrower. This was rectified in the subsequent letter of the 16th of October. Now, one point perhaps I'd like to make a mistake. This morning I heard Mr. Guthrie say that the letter, the bank letter, did not meet the requirements of condition 15 of let me say as a first point that a further letter to meet the condition was a letter from H Capital Partners, which is at MS 629. MS 629. To this letter, oh, of how the equity was to be provided between the different at or after financial close. Now, of course, here we are dealing with equity, but as my Lord Fix rightly pointed out this morning, this project was going to be financed both by debt as well as equity. In fact, if we look at MS page 581, MS page 581, this refers to the debates in the Mauritius National Assembly, which took place on the 25th of March 2014. We find in the second answer to Mr. Duval, by Mr. Duval to Mr. Béranger, he says, Sir, as far as checking the financial capability, financial standing and quality of the people who would invest in the project, obviously we need to know who will be the final shareholders and their financiers. It is clear, Mr. Speaker, sir, that City Power is a promoter of the project that will seek to gather a consortium around it to finance a project, and at the same time 80% of the project is meant to be financed by loans. So it was pretty clear to government that there was going to be loan financing and that there was going to be equity financing provided by certain parties, including City Power, including the CB. So the point is that when it came to the meetings that were held on the 15th and 16th of January 2015, according to City Power, no issue at all was raised concerning the bank letters that were meant to give comfort concerning the debt financing. No issue at all was raised. Indeed, if we look at the affidavit evidence of Mrs. Jawahir, which is and 19, MS 619, we can start at MS 618 because from paragraph 9 9.1, 9.2, she explains the first joint letter from Bank of America and Bank of India. And then at MS 619, she states how issue was taken by the Ministry of Finance, that's at 9.4, 11 months after the amended letter dated 10th of October was communicated. And the Ministry of Finance states belatedly a number of things that Mrs. Jawar here mentions in her affidavit. But the point I'm trying to make, Lord, is there was never any issue raised in relation to the bank's letter. And the discussions of 15th and 16th of January really focused on equity finance. And a letter of comfort was required in respect of the equity financing, notwithstanding the letter of AGK Capital Partners. We have referred to it at MS 629. Therefore, in my humble submission, one may not, at the merit stage of a JR application, come up with the point that, oh, but the letter from the banks did not satisfy condition 15. Well, if it did not, why did no one say anything about it? The reason is quite simply that everybody was perfectly happy that debt financing was going to be provided to the tune of 280 million, and everything focused on equity financing, because that was the critical step which City Power had to comfort the government with in order for the project to go through. And on this point, Lord, the City Power has mentioned that the statement made to the National Assembly by the Minister of Energy are really putting the cart before the horse. First of all, we have on the 3rd of March, the Minister of Energy telling us of a new condition of license, that we have to disclose the source of funds as opposed to financial capabilities. And at that point in time, he says, my ministry is going to recommend to government not to go ahead with this project. But he's not even aware of the comfort letter submitted on the 27th of February. He's not even aware of this. And fortunately, the respondent is quick to react to this statement, as we can see from the affidavit of its representative at MS 268, paragraph 42. So we have it at MS 268 that on the 5th of March, the Minister of Energy had to concede. He had to tell the House, yesterday on the 4th of March, at 14:36 hours, an email was received from one Dato Subramaniam, reading as follows. So he gives lecture of the email, and then he says that email included a letter informing me that City Power had on the 27th February last delivered to the Ministry of Finance a letter of comfort alleged to be in compliance with condition 15. I'm going to table a copy of that letter. So he puts in the letter from Avendus, and disconcertingly, he adds, I have consulted my colleague, the Minister of Finance, who agrees that this letter is not a letter of comfort as required by government. One would have expected the Minister of Finance to say something to the House, and he lets the Minister of Energy occupy the center stage and speak on his behalf. Now, in my respectful submission to the board, several points can be made on this statement, which I submit should be taken with a very, very large pinch of salt. First, the minister, when he announced his ministry would not recommend the project to go ahead, was not aware of the letter of the 27th. Secondly, he never informed City Power of any decision taken by government on the 6th of February that its source of funding within a reasonable delay has to be disclosed, failing which the project would not be implemented. Perhaps on this point, my Lord, I have to refer the board to part of the proceedings at page 711, MS 711, top of the page, where I was addressing the court in submission. And I said, on behalf of the applicant, it is our respectful submission. If indeed there was such a decision, it ought to have been communicated to the applicant. Now, we have, as a matter of principle, looked at all cabinet decisions for the 6th of February, and I refer to tab 9. Unfortunately, tab 9 does not form part of the record. And I said, if your ladyships go through all the decisions said to have been taken on the 6th of February, there is none concerning City Power. It will be the respectful submission of the applicant that the alleged government decision of the 6th of May is a colorable device artificially created by the first co-respondent in order to give credibility to his purpose of bringing the project to a halt. And I stand, of course, by what I have said. One further point on this, Lord. The CEB in its affidavit, both at leave stage, it was the only party to file an affidavit at leave stage, MS 176, 178, paragraph 11, and at merit stage, the affidavit of the contents are the same, MS 564, 566. As per the financial clause of the power purchase agreement, which the respondent had signed with the CB in 2013, the respondent needed to provide a signed implementation agreement. The CB noted that up to now, the applicant failed to produce the signed implementation agreement, and therefore the project cannot proceed. Well, the board will, I'm sure, note that if the implementation agreement was not signed, it was none of the doings of the respondent that had pressed the Ministry of Energy to get on with it, but the Ministry of Energy instead took comfort that condition 15 of the EIA license had not been met, and therefore he was not going to sign the implementation agreement. Now, my colleague, Mr. Chetty, stated this morning that clause 4 of the implementation agreement lends force to his argument, and he said that government as co-principal debtor would be a purchaser of services and would be legitimately invested to pay for such services. Now, what are those services? I may well ask. Not stationary. It is purely and simply the provision of electricity to the population of Mauritius. And this is where the statutory provisions of the CEB Act provide a statutory underpinning for the JR application. This is where it provides the statutory underpinning. Now, at the time I argued this case at leave stage 4 years ago, I thought it appropriate to refer to Lord Bingham's rule of law, and the board will find this at MS 202-203, where the importance of the rule of law was stressed, was emphasized by Lord Bingham. Well, since I have come across the judgment of my Lord, Lord Reid, in the case of Unison and the Lord Chancellor, it's in the supplemental bundle at tab 4. And I found paragraph 68 of the judgment particularly inspiring, where your Lordship explains at the heart of the concept of law is the idea that society is governed by law, and the paragraph concludes that the role of the court itself includes ensuring that the executive branch of government carries out its functions in accordance with the law, not in breach of the law or in defiance of the law. Now, I have referred to the case of Unison because it brings out clearly the role of the court to ensure that ministers in their decisions and in their decision-making process follow the rule of law. Now, it is difficult to imagine that the court in Mauritius, seized by this application for JR, the court that has the duty to uphold the rule of law, would have stood by and allowed such decision-making process and decisions to be carried out by the appellants with impunity. That could not have been, Lord. So, with it, I will move on to, although I have slightly touched upon it, I will move on to the point of raised by the appellants concerning amenability. But perhaps before amenability, because I believe that amenability is something that one looks at as well, after have looked at the merits of a JR application, perhaps I should start with the merits and then come back to the point of amenability. Now, the board would know that the court found that the grounds invoked by the Ministry of Finance to hold that condition 15 of the license has not been satisfied are unreasonable and irrational. Now, in our written case, we have identified the reasons why such decision was unreasonable and irrational at MS 1104, 1107 at paragraph 123 and 1231 to 1237. Now, the board will certainly note the reasons given by the Ministry of Finance to decide that letter of comfort was not satisfactory. Suffice it for me to say that the reasons invoked in the affidavit of Mr. Sundram, namely that the letter was not on its proper letterhead, that the letter did not bear two signatures, that the letter was not accompanied by board resolution, are reasons which certainly, in my humble submission, do not warrant a rejection, an outright rejection of the comfort letter, unless that was the colorable device that was used by the appellants to abort the project, because it was too hot a potato for the new government to handle after its coming into power. Now, your ladyship and your lordships will note that the unreasonableness and irrationality, insofar as the Ministry of Energy is concerned, are identified at MS 1102 to 1103 at paragraph 121 and subparagraphs 1211 to 1217. And these reasons are fully supported by the evidence on record. Now, we say the decision is unreasonable and irrational because it is based solely on the failure of City Power to allegedly satisfy condition 15 of its license. Now, the board will note the circularity resulting from the decision of the ministry, because if the implementation agreement is not executed, the power purchase agreement is not effective and debt financing cannot be raised. If debt financing cannot be raised, financial close cannot be achieved. If financial close cannot be achieved, condition 15 cannot be met. The court found that this was completely unreasonable and irrational. Now, I referred the court in Mauritius to the case of Coughlin in respect of the legitimate expectation of City Power to take its project to fruition. We must not forget, my lady and lords, that City Power battled its way in order to obtain an EIA license by a decision of the tribunal. It was a licensee by a decision of the tribunal. And of course, the tribunal said the Department of Environment can add a number of other conditions to the license as they thought appropriate. And conditions were added. And amongst those conditions, condition 15 was added. It was a condition that had to be satisfied. according to the Minister of Finance. And we have it on record in evidence that after receiving the Avender's letter, it was on the 9th of February, it was on the 9th of March that the Ministry of Finance wrote to the Ministry of Energy to state that the letter of comfort did not meet its requirements. If that was done on the 9th of March, how is it that on the 3rd of March, the Minister of Energy, without even referring to that letter, without having waited for the letter from the Ministry of Finance, decided that the project could not go through because the promoter has not met this condition? This is why I said, lady and my lord, that this is a colorable device that was used by the appellants in order to abort the project. Lord, the board will take note of the fact that the acts or decisions being challenged by the respondent are, first, the wrongful interpretation of condition 15 by the appellants, and secondly, the refusal to sign the implementation agreement on the only reason that condition 15 had not been satisfied. Now, surely, the fact whether a license condition is or is not satisfied is a matter of public law. The public body is exercising a regulatory duty in deciding whether a license condition is satisfied, having regard to the legislation. Now, in the case of an EIA license, it is monitored according to Section 28A of the Environment Protection Act to ensure that license conditions are complied and appropriate measures are taken if a condition has not been complied. Now, I understand that the powers of the Minister of Energy devolved to the Minister of Finance by virtue of Section 15, but surely the statutory framework under which the license condition was imposed had to be observed in terms of due process. In other words, it is not because the Minister of Finance had to be satisfied that the condition that City Power had to provide proof of its financial capabilities, that the requirements of due process did not apply. My Lord, the wider context, so by themselves, the acts, the decisions taken by the appellants, in my humble submission, are judicially reviewable because they are matters of public law. In addition, the wider context concerns the partnership agreement between the CB and the respondent, the latter having the statutory obligation to provide electricity to the population of Mauritius. The implementation agreement, to that extent, in my humble submission, is simply a cog in the machinery provided under the PPA, the Power Purchase Agreement, to ensure that electricity produced by the power plant and sold to the CB will be paid for by government in a default situation by the CB, the Ministry of Energy, as part of government policy, encouraged private-public partnership for such an important project which required foreign investment. It decided to refer the project to CB. The signature of the implementation agreement was a condition precedent to the effectiveness of the power purchase agreement. But what the appellants have done in the exercise of their public duties is to wrongly interpret, is to wrongly construe condition 15 to torpedo and abort the project. They did so without respecting procedural rules of fairness, without any hearing, without informing the licensee of any reason why it purportedly failed to satisfy one of its license conditions. The respondent in these circumstances, milady and lords, had no effective remedy against such wrong public behavior other than to have recourse to judicial review, to have the court pronounce on whether such decisions taken did or did not flout the rule of law. The situation that City Power found itself, I can say, is similar to the claimant's position in the case of Joanna Trafford against Blackpool Borough Council. It's a decision which you will find at MS 1462 to 1482 in the bundle of authorities. And I would like in particular in the case to refer MS 1476, 1477, paragraphs 58 to 61. Now, in that case, when determining the issue of amenability, that's 1475, it starts from 1476. In that case, when determining the issue of amenability, the judge correctly found that it is not a case of Miss Trafford seeking to challenge the council's decision, only contracted out leases so that she had no right to renewal. Instead, the case was having been subjected to a decision that the council would not even consider her request for a new tenancy, even though she had this option. And at paragraph 59, the claimant contended that such a decision was vitiated because it was taken for an unintended purpose. It was irrational. It was procedurally unfair. And these challenges were held to be sufficiently genuine and substantial to raise a sufficient public element to render the decision amenable. In our case as well, it is my respectful submission that we have raised genuine and substantial reasons before the court to challenge the decisions of the appellants. The more so, Lords, because as a licensee, we had the right, we had expectation to proceed with the power plant project after having been issued with a license. We had the right to a fair hearing if our license was to be varied, was to be refused, or was to be revoked by the responsible authorities. When we discussed the joint draft implementation agreement, I concede it was a draft agreement. It was not signed, but it was a joint draft that had been discussed as far back as 18th of July 2014, and comments were made on the 21st of July to that draft. And from 21st of July until January 2015, none of the appellants had anything to say on that draft. Had anything to say. So it is going to be my respectful submission, Lord, that City Power had the expectation of taking its project to fruition. City Power had the expectation to be given a hearing and to be consulted if the government of the day was minded to stop the project.
Yes. Can I just ask you about that? In relation to the decision to terminate the project, as I understand it, you're relying on the concept of a legitimate expectation. So far as the loss of a license because of the non-fulfillment of a condition is concerned, are you relying on that principle or on the right to a fair hearing established in other cases concerned with licenses? For example, Lord Denning's case a long time ago now, ex parte Hook, and other cases
Yes.
to do with either the non-renewal of a license or the termination of an existing license.
Well, once we had a license, we had rights under the license. We had rights under the license. And one such right that we had was the right to be informed if the appellants had decided to stop the project. We had the right to be informed if our letter of comfort did not satisfy the requirements of the Ministry of Energy. The point we are making, Lord, is that the Ministry of Finance made what we consider to be representations which were clear and unambiguous when it reviewed the draft implementation agreement of July 2014, that we would have a 9-month time frame from the signature of the agreement to satisfy condition 15.
But Mr. Bassett, so can I ask,
Yes.
so far as that is concerned, that's, I think you're referring to clause 7 in the draft implementation agreement, but wasn't that all subject to contract because the contract had not been signed?
You are referring to clause 7B, Lord?
I am, but that's because I was inferring that that's what you were referring to when you were saying that there was a legitimate expectation
Yes.
that there would be 9
Yes.
months.
Yes. Clause 7B, Lord, was inserted according to the note which is to be found at the request of the Ministry of Finance. This is why I'm saying that when the Ministry of Finance reviewed the draft, it would realize that it is from the time of the implementation of agreement is signed that we would have a time period within which to satisfy clause 15,
Yes,
condition 15 of the EIA license.
The point
and it simply doesn't make sense
I'm sorry.
to us to say in early March 2015, oh, you have not, because you've provided a letter of comfort which does not satisfy the requirements of the Ministry of Finance, your project should not go ahead.
Mr. Bassett,
we were not even called and told, well, we are not happy with your letter, but could you make sure that you attend to this or that specific requirement?
Mr. Bassett,
we were not even invited to do that.
The point that I wanted to put to you in relation to legitimate expectation based on Clause 7 was,
yes.
I think in your own formulation you accept that for a legitimate expectation to arise, the representation has to be clear, unambiguous, devoid of
Absolutely.
relevant qualification.
Absolutely.
And I was really asking how you can say that Clause 7 in a document which is subject to contract can be said to be devoid of relevant qualification. Isn't the qualification that one waits to see if the contract is executed and entered into?
I have to agree with my Lord Sales that it is difficult to stretch Clause 7 to an express representation which is clear and unambiguous. I have to admit that because the contract was still subject to discussion, this is so. But it's not really Clause 7 that I'm relying upon, my Lord. It is the note to the clause. It is the note which set out what is the understanding of City Power following concerns expressed, points made by the Ministry of Finance. And that note, as distinct from Clause 7 itself, it's the note to Clause 7, can be interpreted as a representation which is clear and unambiguous that a City Power would have a 9-month time frame.
But isn't that note a representation by CT Power? My understanding is that that note comes from the CT Power side of the drafting negotiation.
That is correct, my lord, but that note also takes on board discussions that were held with the Ministry of Finance, and City Power expresses the hope that 7.2 would allay the concerns of the Ministry of Finance with regard to Clause 15. But, Lord, what is important is that in context, what is used to stop the project is condition 15. And I'm going back to the note again, Lord, which is right in front of me. And it says, this condition has been included at the request of the Ministry of Finance, who have confirmed that if condition 15 is included in the implementation agreement, because it wasn't there before, within a 9 months time frame, the proposed amendments to the implementation agreement as per our earlier draft dated 4/7 are acceptable to them. So this is what City Power says, correct? But it says it has been included at the request of the Ministry of Finance. The word used here is confirmed. And the Ministry of Finance takes no issue with this between July and March 2015.
But Mr. Bassett, if one looks at the note, even the first sentence seems to be conditional, because it's saying if condition 15 of the EIA license is included, then they're happy with the drafting. There doesn't seem to be an unambiguous representation that it must be, or that they will be content if it is?
This is correct, Lord. This is correct. It is conditional. It is conditional. But then, we should not forget that what stops the whole project is an interpretation which is placed by the appellants on condition 15, which says, you have not provided a letter of comfort that suits our requirements, and therefore we are not going to allow this project to go through, because condition 15 has not been satisfied. I'm just looking at my notes, my Lord, if there is any other point which I would like to make. Yes, perhaps two last points. One is in relation to the right of a licensee whose license is going to be threatened by revocation. On this, perhaps I would refer the board to MS page 1620, paragraph 7020 at the 5th line. This is a referral to Professor De Smith's judicial review, yes, where I read that there is, from line 6, a strong presumption exists that a person whose license is threatened with revocation should receive prior notice of that fact and an opportunity to be heard. The presumption should be especially strong where revocation causes deprivation of livelihood or serious pecuniary loss, or carries an implication of misconduct. So my final submissions, Lord, is the respondent was deprived of any opportunity to be heard when on the 3rd of March, the Minister of Energy concluded that the condition 15 had not been met and the project should not go through, in effect rendering the license OTOs. I will also submit that the court rightly concluded at MS 844, paragraph 56, that fairness required that City Power be informed why the letter of comfort did not satisfy the requirements of the Minister of Finance, and be given an opportunity why, in its view, it did so. So the court rightly concluded, in my respectful submission, that City Power had a legitimate expectation to be treated fairly and given the opportunity to answer the objection of the Minister of Finance. Now, the court, my lords, as my Lord Kerr, observed in the very recent case of Geraldine Finucane, at paragraph 62 of the judgment, my Lord Kerr said, the court is the final arbiter of fairness in this context, and a matter sounding on the question of fairness is whether the alteration in policy frustrates any reliance which the person or group has placed on it. Well, my submission will be the court, as a final arbiter of fairness, was right to make the declarations that it did in the circumstances. The appellant ministries could not ride roughshod on the rights of City Power as a licensee in the circumstances that we have highlighted in our case. Lord, milady, unless I can be of further assistance to the board, I have done.
Well, I wonder if I could pursue one matter with you, Mr. Bassett. It's just to try to understand better how the license operates. We have in the supplementary bundle of authorities
Yes.
the Environmental Protection Act.
Yes.
And the license we're concerned with, what I think was one granted under Section 15 of the Act.
Section 15.
Yes.
Yes, I will turn to it, my lord.
It's in tab 3. It's got it's got a number E12-14.
Yes, my lord.
12-14. I'm not sure. I'll go ahead anyway.
Section 15.
Yes. Now it's headed prohibition to carry out an undertaking, and in
Correct.
subsection 2 it tells us that
Yes.
no proponent shall commence or cause to be commenced B
Yes.
a proposed new undertaking specified in Part B of the 5th Schedule without an EIA license. And Part
Correct.
B of the 5th Schedule is on page E1269, and it includes, 68 and 69, and it includes power generating plants.
This is in the first schedule, my lord?
The fifth
No, second schedule.
The 5th Schedule, Part B, and it's listed
Fifth
as item 36 in the 5th
Part
Schedule.
B, item 36.
Yeah,
Yes, power generating plants.
yes. So under Section 15, nobody can commence an undertaking involving a power generating plant without an EIA license.
Yes.
And C, any undertaking more than 3 years after the issue of an EIA license, unless the
Yes.
minister otherwise determines. So,
Yes.
and Section 18 of the Act, I beg your pardon, Section 23 of the Act, Section 23, subsection 2, provides for the issue of an EIA license on conditions.
Correct.
So I think what we're looking at is a license granted under Section 15. I think, I mean, I've only been looking at this in the last few minutes, but it looks as if it's a license granted under Section 15(2)(b) with conditions imposed under Section 23(2)(a). Now,
I will just look at the license, my lord.
yep,
License, which page, please?
Part 4.
The license, my lord, we find it at
page 383, I think.
page 383 onwards.
Yes.
Page 383, yes.
And it does also contain some conditions imposed by the tribunal. So I dare say
Yes,
there's
1
another...
to 11.
Yes,
1 to
presumably-
11 were imposed by the tribunal.
Yeah, there'll be presumably another provision that deals with that. But condition 15, I think, is
Yes.
one not imposed by the tribunal but by the ministry.
That's correct.
Yeah. Now, some of the conditions relate to matters to be done during the carrying out of the construction works.
That's correct.
For example, condition 14, the Department of Environment is to be informed of the progress of the works and the date of completion.
That's correct.
Right. And others, it may be condition 15 should be understood as being one to be complied with before the works begin.
It says the duration of the project. So that would assume the commencement of the works until its completion.
Yes.
But the words
So,
for
so the
duration-
financial capabilities is to be gauged
Yeah.
from
words-
the commencement
words
of the works
for
until
the
completion.
duration of the project have to be read in context. Its financial capabilities for the duration of the project. That, as my Lord points out, seems to imply that that's an undertaking that must be discharged in advance.
Yes, my Lord. And the question is, how is it discharged?
Yeah, of
when you
course,
know
right,
that
right.
the project is to be
Yeah.
done both by debt funding and equity funding.
Yes. Now, I appreciate in the present case you take issue with the decision that the letter of comfort wasn't satisfactory. Just say, for the sake of argument, that the company undertaking the project accepted that what it had put forward wasn't sufficient. It could then still put forward additional material, could it not?
Yes,
Yeah. And it would be able to
but it
do...
wasn't given the chance.
Well, yes, and it would be able to do that, I think, up until either the... Well, it would be able to do it, I think, for up to 3 years after the license had been issued, because 3
Yes.
years is the deadline imposed by the Act in Section 15
Indeed.
2C.
Indeed.
Right. So a decision that condition 15 had not been complied with at a particular time wouldn't in itself revoke the license, I think. The license would still exist until the third anniversary had passed.
Yes.
Is that right? I don't want to rush you into
Yes.
answers, but I'm
Yes.
just...
Yes. I mean, the license would still continue until the 23rd of January 2016.
Yes.
In fact, it expired in 2016.
Yes.
City Power applied to the Ministry of Environment for an extension of the license, and the extension was refused. Hence, the pleading which
Yes.
we find at paragraph 83
Yes.
of the plaint with summons of the statement of claim.
Yes. Yes. This doesn't in any way detract from your argument that the ministry should have been satisfied with what it was given.
Yes.
But I just wanted to have a better understanding of how this legislation in relation to licenses operates. So thank you very much. Any other questions? No, we've no other questions for you at the moment, Mr. Bassett. Thank you very much.
Thank you. Thank you, my Lord.
Mr. Guthrie.
Well, I didn't propose to be very long. I just wanted to respond to the submission that it was not possible for the respondent to bring the civil claim without having first brought the judicial review claim, because they did not know what had happened in relation to the letter of comfort in particular, I think, until the course of the proceedings. My Lords, that isn't right. If we look at the affidavit which was filed when the judicial review proceedings were commenced, that is at the beginning of the bundle. On pages 13 to 14, we see the the complaints about condition 15, including the statement by the government that the company had undertaken to state its source of funding and had not done so. At page 18, we see exactly the same case in relation to the terms of the implementation agreement, which they say had been settled as long ago as 2009. We simply submit that the ordinary civil claim would have produced precisely the same amount of information in ordinary procedures as a judicial review claim. It does make something of a difference. Before I just make the comment in passing, but there's really no use in referring to the implementation agreement which was drafted in 2009, which is before the events before the license had been granted. But this morning I was asked about the effect of the findings in the judicial review claim on the civil claim. And it suggested that insofar as they deal with the same matters, which if one puts a description of folklore on it, would be raised judicata so far as the civil claim is concerned. And we respectfully submit that that is an illustration, really, of why it is dangerous and, in our submission, wrong to have the two sets of proceedings running in tandem. And at the end of the day, the claimant saying, well, this has all been gone into in judicial review proceedings and you're bound by the findings in those proceedings, when the situation could have been confined to one set of proceedings. But in the present case, we say that it would be completely wrong for the claimant in the civil claim, which is due to be heard at some time in the future, to be able to point to the judgment in the Supreme Court and say, well, that's game, set, and match to me because these findings have been made against you. Assuming for the moment that your lordships might be against me on the amenability to judicial review point, we then come to the question of whether the findings which were made in those proceedings could possibly be regarded as safe. And, my lord, I won't go through them in detail again, but you'll recall what I had to say about them this morning. They're at pages, I think, 840 and thereafter in the electronic bundle. In relation to the implementation agreement, page 841, well, they set out clause condition 7 without noting that it is conditional, which I think my learned friend now accepts. They don't include the note. My learned friend really can't, I think, persuade you that that note amounts to an unambiguous representation when it ends with the word, we hope this is in line with what the government of Mauritius would like. And the further observations regarding the importance of the signature from the perspective of CT Power and the joint discussion draft, which the court appeared to think was in favour of CT Power's point, and the failure to, well, I'll just leave it at that for the moment. I mean, those findings, in my respectful submission, cannot be allowed to stand. And in relation to condition 15, we have the findings of a legitimate expectation. And I don't think I need really add to what I said about that this morning. This is not a case where one can demonstrate the generation of a legitimate expectation in relation to the confirming that condition 15 had been complied with. My Lord, if the reasons which the court gave for the conclusions it's reached are flawed, then the judgment should be set aside. And I heard with interest your Lordship's debate with Mr. Bassett about whether it would still have been possible for the condition 15 to have been complied with. Well, possibly it would have been, but your Lordship shouldn't substitute some other reasons for holding that the government were in breach of some public duty for the ones which were actually given by the court below. But that would be a dangerous thing to do. In our respectful submission, the judgment should simply be set aside, and the case which my learned friend wishes to make, if he chooses, if you like, to grab the bridle of the horse that your Lordship put forward and says, well, it was unlawful of the government to kick us out when we could still have come back and complied with the condition, then he can do that in the civil claim. Yeah. But there's no reason, in our respectful submission, to do anything other on this appeal than to set the judgment aside.
No, I wasn't meaning to suggest that, because it's not something that's ever been raised.
Well, exactly. Well, it might be raised. It might be raised in the civil claim now, I suppose. But the fact is that if we are faced with declarations by the Supreme Court, which, well, your Lordship will recall, they're right at the end of the judgment on page 845, that in relation to condition 15, the Minister of Finance, or Ministry of Finance, and through him the state, have acted unreasonably, irrationally, and in breach of the legitimate expectation of the applicant. And the same thing with the addition of being misconceived in relation to the Minister of the Environment for certain particular reasons, which in our respectful submission simply don't hold water and shouldn't be allowed to continue, because rather similarly but on the other way around to the MTEL case, they would present a great obstacle to us in a proper defence of the civil claim. And if other arguments, or there are other reasons for supposing that the government acted in some way less than perfectly, then they can be raised at that stage. Yes,
I should reassure you, it certainly wasn't my intention to raise or encourage that sort of argument. It's simply, having heard submissions about the effect of the government's decision on the licence as being that it revoked the licence, one has to look at the statute to see whether that may be well-founded.
A bit frightened with false fire then. I don't say any more about that. The only other matter that I thought I ought just to raise is I think my Lord Briggs asked if we could send the supplemental note and the complaint with summons by email. So presumably you would still like us to do that.
Yes, yes, if you'd be so good.
Yes. I don't know if there are any other matters about which I can help the Lordships.
I don't think so, Mr. Guthrie. Thank you. Well, we're very grateful to all counsel, first of all, for bearing with the technological problems we've had to deal with, and also for the assistance that you've all given to the court. We'll now consider our judgment.